Hi, my name is Wayne Mortensen. I'm an attorney here in Arizona, and today I'm going to talk to you a little bit about bankruptcy basics. And really what I want to talk about today is kind of the process that you go through when you file a bankruptcy, or what my clients go through when they file a bankruptcy. So I've kind of split it down into 7 steps, okay? And again, these are the basic steps that everyone goes through when they file a bankruptcy. So the first step is to, number one, most importantly, get your free consultation with qualified attorney, okay? When this is so important, okay? You can't underestimate the value of this pre-bankruptcy consultation. The last thing you want to do is be the smartest kid in the room when it comes to getting ready to file a bankruptcy. I have so many clients who come to my office and they tell me all of the wonderful things they've done to get ready to file bankruptcy, and most of them are fraudulent or will get them into some kind of a mess. They will have involved family members that sometimes get that family member into a mess. So it's really important when you realize you're kind of heading down that hill and you might be filing a bankruptcy, before you do anything, before you make moves, go talk to a qualified attorney. We offer a free consultation by phone or in the office. There's no obligation. We're not signing you up when you come in. So just come in and get the information. We're confident in our abilities, and we've done this. I've done this for 25 years. I've helped literally thousands and thousands of people file bankruptcy, and I've consulted thousands and thousands of people. There's really no issues that surprise me or really stump me. I usually am able to get through and walk people through it. Number 2, after the pre-bankruptcy consultation, with the assistance of your attorney, you're going to prepare to file the case. That means you're going to get the documents ready. You're going to get the documents to them. This is really important, okay? You can't slack on the documents. You can't show up at the office and say, oh, we don't have this document or that document. But your attorney will get the case prepared, and then you go to file it. And in all of these steps, okay, you're going to be reviewing and making sure you've got all your ducks in a row, okay? You don't want to, again, underestimate the importance of having accurate information to give to the court, okay? Number 3, you're going to file your case, okay? Now, typically, if you file with an attorney, you're not going to be there on the day of filing. But that filing of the case is really an important date and time. And it's not, oh, we're just going to file your case today. It's something that you want to think about, okay? Bankruptcy is all about timing, and good timing, okay? There are many things that can go wrong if you file at the wrong time. Not only with means tests, with transfers of assets, with payment of creditors. There's all kinds of things where timing issues come into play, and you have to know when is going to be the right time to file your case to maximize your discharge and to protect things that you want to protect. So don't underestimate that. Number 4, after you file your case, about a month and a half, you're going to go to court. Okay, now it's really not court. What you're actually doing is you're going to go to a 341 meeting. And in Phoenix and Tucson, those meeting rooms are at the courthouse. So that's why I call it go to court. But actually you're going to a 341 meeting. And 341 is simply the code section that outlines that you're to attend a meeting. So you're going to go to the meeting, and that's where the trustee is going to have your paperwork. They're going to go through it page by page, and they're going to look and see if they have any questions for you, if there's any concerns. They might ask you about things that you've done in the past. So it's really important, and you have to go to this meeting or they can dismiss your case. Number 5, after you go to court, you may have to deal with the U.S. Trustee's office, your interim trustee, and you might have to deal with creditors. Now, the U.S. Trustee's office, this is not common. Okay, this is when you deal with the trustee's office in relation to, for example, the means test or a bad faith type of issue. If the U.S. trustee's office sees that you didn't qualify for a Chapter 7, yet you filed a Chapter 7, they very well could want some information and to overcome the presumption of abuse is what they call it. And so the dealing with the Chapter 7 trustee or the U.S. trustee's office is something that does happen in these cases. Now, I'm going to tell you right now, I've filed cases where I know for a fact I'm going to be dealing with the U.S. Trustee's office. I still file them, even though I know my client may not have qualified under the means test at that certain time. But I've got my plan of action, and generally we get through the U.S. Trustee's office and we're able to proceed with our Chapter 7 case. The trustee is the one you'll meet at the 341 meeting. They're the ones that will ask you the questions about your paperwork. After you've done that, oh, and then there's the creditors. If a creditor sees that you've done something incorrect, wrong, they don't like, they feel like you've incurred the debt through fraud or false pretenses, that creditor can actually come back and create problems for you in bankruptcy. If there's no issues here, then the next thing that happens is a discharge. Now, the discharge can throw people off. A lot of times people think, oh, I got my discharge, my debts are gone, or certain debts are gone. Certain debts don't go away, like certain taxes and student loans. But I got my discharge, so I'm done. I don't have to cooperate with the trustee anymore. Wrong. You still must cooperate with the trustee. The trustee needs your information. If they've asked you for next year's tax returns, you better get them next year's tax returns. They can go into court and they can ask that your discharge be revoked. Okay, and you don't want that. You don't need that hassle. So if at this 341 meeting, the trustee asks you for certain documents, you get the trustee those documents, or else you could be in some serious problems. Number 7, after the discharge, you need to understand the closing of your case. Okay, this is something that stumps people who are in bankruptcy. It stumps my clients. It stumps attorneys who don't understand it. And there are certain legal implications for when this case closes. So you need to understand that concept, because you might decide, hey, I'm not going to sell my house while my case is still pending and it's still open. So there are different things to go through it. It's a very fact-specific type of a conversation that you'll have with your attorney. So my name is Wayne Mortensen. I'm an Arizona bankruptcy attorney. I've done it for 25 years. I know what I'm doing. Give me a call if you have questions about bankruptcy and would like a free consultation. I'll look forward to talking to you. Thanks.